Hello friends, welcome to iExamB. Today we are going to start a new series which is specially dedicated for judicial exams. In this series we will be discussing one question every day of mains. This will be Judiciary Mains answer writing practice. We will discuss a question, we will also discuss how to approach the answer and what to write in the answer of this question. We will discuss a mix of questions from various acts and also mix of questions from various state judicial examinations. In this series, we'll be catering to previous year questions mostly, and we'll discuss in detail what should be the answer to those questions. So here the question is, explain and illustrate the difference between preparation to commit an offence and attempt to commit an offence. So here we can see this is a general question from criminal law and majorly caters to Indian Penal Code. अब आप एक चीज ध्यान रखिए कि जब भी आप किसी क्वेश्चन का आंसर कर रही हैं तो उसमें 3 पार्ट्स होंगे. पहला इंट्रोडक्शन, देन द बॉडी ऑफ द आंसर एंड एट द एंड कंक्लूजन. इंट्रोडक्शन और कंक्लूजन बहुत ही ब्रीफ होते हैं, शॉर्ट में होते हैं, और बॉडी में आपका डिटेल्ड आंसर होता है. सो देयर विल बी 1 पैराग्राफ फॉर इंट्रोडक्शन, 1 for conclusion, and body can be divided into 3, 4, 5 paragraphs based on the marks which are devoted to the answer and also based on requirement of the question. अब ऐसा भी हो सकता है कि किसी क्वेश्चन में इतना कंटेंट, इतना मटेरियल ही ना हो कि आपको बॉडी में 4-5 पैराग्राफ्स बनाने की जरूरत पड़े. तो हो सकता है उस क्वेश्चन में आपके 2-3 पैराग्राफ्स में ही बॉडी का पार्ट खत्म हो जाए एंड इंट्रोडक्शन एंड कंक्लूजन विल बी देयर. तो अब अगर हम इस क्वेश्चन को समझें तो यहाँ पर क्वेश्चन की रिक्वायरमेंट है कि आप प्रिपरेशन टू कमिट एन ऑफेंस एंड अटेम्प्ट टू कमिट एन ऑफेंस को एक्सप्लेन करें और उसके डिफरेंस को बताएं. सो इंट्रोडक्शन विल कंसिस्ट ऑफ एक्सप्लेनेशन ऑफ द स्टेजेस ऑफ क्राइम because we know preparation to commit an offense and attempt to commit an offense are 2 of the stages of a crime out of 4 stages. तो सबसे पहले आप इसमें ये बताएंगे commission of a crime has 4 stages: intention, preparation, attempt, and then actual and complete act. Now we will define each stage one by one. So when we talk about intention, intention is the first stage which implies forming an idea in the mind to do a particular act. Intention alone without action is not punishable. Just because आपके दिमाग में कोई बात आ गई है, कोई offense या crime conduct करने का आपने सोचा है, that alone is not punishable. In order to establish criminal liability, it is well established that both actus rea and mens rea should be present. So here you can also bring in the terms actus rea and mens rea and define those. Mens rea is the intention or knowledge of wrongdoing, while actus rea is the action part. So mere intention shall not constitute a crime, as it is impossible to know the intentions of a person without the act. So this is what is the first stage. Then you will move on to the second stage in your answer, preparation. Preparation is the second stage which involves around arranging means etc. for commission of a crime. So in preparation we will have a lot of things. For example, अगर किसी के दिमाग में idea आ गया है, there is intention to commit an offense, then the next step is he will go to prepare for means to commit that offense. अगर किसी को shoot करना है तो pistol खरीदेगा, mask खरीदेगा. So these all comes in arranging means etc. for the commission of crime. However, this is the stage in which the offender still has opportunity to change his idea and withdraw from the execution. अभी भी अगर किसी ने पिस्टल खरीद लिया है तो जरूरी नहीं है कि वो जाकर गोली मारे. So here also he has the opportunity to change his idea, to just throw away the pistol or to just return the pistol. So in preparation stage, offender still has the opportunity to change his idea and withdraw from the execution. Thus, the test of locus poenitentiae is applied where the culpability of preparation is in question. Locus poenitentiae का मतलब होता है the idea, the tendency to withdraw from execution of that offense or execution of that contract. तो प्रिपरेशन पनिशेबल है या नहीं, इसके लिए ये वाला टेस्ट अप्लाई कर सकते हैं. Therefore, except in certain exceptional situations like dacoity under section 399 of IPC, waging war under section number 122 of IPC, or counterfeiting coins and government stamps etc., preparation of crime is not punishable. तो इन एरियाज को छोड़कर, इन सेक्शंस को छोड़कर बाकी सभी सेक्शंस में preparation is not made punishable because it is not possible to prove that a person made preparation to execute the crime. So in this way you can define the second stage, that is preparation. Now coming to the third stage, after forming an intention and preparing for the crime, if offender doesn't act in implementation of his intention, it amounts to attempt. Therefore, attempt means implementation of some overt act, whether the desired effect is there or not. There is a guilty mind, intention बन चुका है, प्रिपरेशन भी हो चुकी है. इंटेंशन और प्रिपरेशन के बाद अगर उसको इम्प्लीमेंट करने के लिए कोई एक्ट किया जाए तो उसे अटेम्प्ट कहा जाता है, चाहे उससे डिजायर्ड रिजल्ट मिले या ना मिले. Attempt therefore reflects the intention of offender by his acts and thus is punishable. In IPC, attempt to commit a particular offence has been specifically and separately made an offence under various provisions for specific crimes. For example, Section 121 has made attempt to wage a war punishable. Section 131 has made attempt to seduce a soldier, sailor or airman from his duty. This is made punishable. In section number 307, attempt to murder. 308, attempt to culpable homicide. 309, attempt to suicide. 356, attempt to commit theft. 357, attempt to wrongfully confine a person. 393, attempt to commit robbery. अगर आपको सभी याद नहीं है तो एटलीस्ट आप 3-4 अगर लिख के आएंगे तो ये आइडिया रहेगा कि आपको आईपीसी के कुछ प्रोविजंस पता है, तो उससे आपका आंसर और स्ट्रॉन्ग लगेगा. Then also there is a general provision related to attempt. Section number 511 of IPC gives a general rule of penalty in case of attempt to commit an offence. तो अगर किसी प्रोविजन या किसी ऑफेंस से रिलेटेड अटेम्प्ट को स्पेसिफिकली पनिशेबल नहीं बोला है तो सेक्शन 511 यूज करके उसको पनिशेबल बनाया जा सकता है. आप यहाँ पर सेक्शन नंबर 511 को डिटेल में एक्सप्लेन भी कर सकते हैं और मेयर मेंशन ऑफ इट इज आल्सो हेल्पफुल इन दिस आंसर. सो दिस इज द थर्ड स्टेज. Now the requirement of the question was explain the preparation and attempt to commit an offence and illustrate the difference. तो अब तक हमने preparation और attempt को explain कर दिया है. Now let's move to the difference. The difference between the preparation and attempt to commit a crime is a crucial one. It can determine the criminal liability of a person. The prime difference between the two is the fact that whether the act that has already been finished during the stages of crime has an impact on the victim. If it has an impact, it is considered to be an attempt. Otherwise, it is considered to be mere preparation. तो मतलब ये है कि अगर प्रेपरेशन और अटेम्प्ट के बीच में डिफ्रेंशिएट करना हो तो ये देखा जाता है कि जितने भी एक्ट अभी तक कर लिए हैं इन द स्टेजेस ऑफ क्राइम, उसका विक्टिम पर क्या इम्पैक्ट रहा है. अगर विक्टिम पर कंसिडरेबल इम्पैक्ट है तो वो अटेम्प्ट हो गया. अगर विक्टिम तक वो बात पहुंची ही नहीं है, विक्टिम पर कोई इम्पैक्ट हुआ ही नहीं है, तो उसे प्रेपरेशन कहा जाएगा. और ये हमने पढ़ लिया है, प्रेपरेशन इज नॉट पनिशेबल except in certain circumstances and attempt is punishable. In order to differentiate between attempt and preparation, there are various tests which the court has evolved over a period of time. The first one is proximity rule. Proximity rule provides that in cases where the accused accomplishes a series of acts in furtherance of his intention to commit a crime, the liability shall be decided upon the proximity with the completion of the act. So whether the act was mere preparation or it was an attempt, ये इस चीज से देखा जाएगा कि उस एक्ट के कंप्लीट होने के कितने क्लोज था द एक्ट विच इज इन क्वेश्चन. फॉर एग्जाम्पल, अगर किसी के पास आइडिया है टू स्टैब अ पर्सन, सो दैट इज द गिल्टी माइंड, देन ही विल गो एंड बाय अ नाइफ. आफ्टर दैट ही गोज टू हिज हाउस विद अ नाइफ. तो क्या ये चीज प्रिपरेशन में आ सकती है या अटेम्प्ट में आ सकती है? एंड लेटर ऑन ही टेक्स आउट हिज नाइफ टू अटैक द पर्सन, बट सडनली द डोरबेल रैंग. तो अब यहां तक लास्ट टू एक्ट्स, whether going to the house was preparation or attempt and whether taking out the knife to stab before the ringing of doorbell was preparation or attempt. ये proximity rule से देखा जा सकता है कि एक्ट की completion होने के कितनी क्लोज था जो लास्ट एक्ट किया गया था. This is one rule. The second rule is locus ponentia. The doctrine of locus ponentia provides that where a person withholds himself from the actual commission of the crime, it would amount to mere preparation. तो अगर कहीं भी withholding हो गई है तो वो preparation तक ही माना जाएगा. The doctrine was propounded after analyzing that a person has reasonable opportunity to withdraw himself from the committing of crime. The third rule that can be used is equivocality test. The equivocality test states that when an act of a person can prove beyond a reasonable doubt the likeliness of committing the crime, it shall constitute as an attempt to commit the crime rather than mere preparation. इक्विवोकल का मतलब है अगर एक से ज्यादा इंटरप्रिटेशन पॉसिबल हो, कोई कंफ्यूजन हो, कोई मिसलीडिंग इंटरप्रिटेशन हो. So this says when an act of a person can prove beyond a reasonable doubt the likeliness of committing the crime. तो दो इंटरप्रिटेशन हो सकते हैं, क्राइम करने की इच्छा थी या क्राइम करने की इच्छा नहीं थी. बट अगर उस एक्ट से बियॉन्ड रीजनेबल डाउट ये प्रूव हो जाए that there was a likeliness of committing the crime, then it shall constitute as an attempt to commit the crime rather than mere preparation. So these three tests can be used in order to differentiate between preparation to commit an offense or attempt to commit an offense. अब यहाँ तक आपने अच्छे से explain भी कर दिया है और differences भी discuss कर दिए. Now to strengthen your answer, add some case laws. Therefore, in Malkiyat Singh versus State of Punjab 1970, it was observed that as a matter of law, preparation for committing an offense is different from attempt to commit it. तो इस केस में ये बोला गया था कि ये दोनों चीजें अलग हैं. The preparation consists in devising or arranging the means or measures necessary for the commission of offense. On the other hand, an attempt to commit the offense is a direct movement towards the commission after preparations are made. In order that a person may be convicted of an attempt to commit a crime, he must be first shown to have an intention to commit the offense and secondly to have done an act which constitute the actus reus of the criminal intention. तो कोई एक्शन होना चाहिए उस क्रिमिनल इंटेंशन का, मेंस रिया एक्टस रिया दोनों होने चाहिए. The judge also gave an example in this case law. If a man buys a box of matches, he cannot be convicted of attempted arson. However, clearly it may be proved that he intended to set fire to a haystack at the time of purchase. So purchase of matches shows that there was some intention. Nor can he be convicted of this offense if he approaches the stack with the matches in his pocket. तब तक भी सिर्फ intention ही show रहा है, preparation show हो गया है. But if he bends down near the stack and lights a match, which he extinguishes on perceiving that he is being watched, he may be guilty of an attempt to burn it. Thus, the test for determining whether the act of the accused person constituted an attempt or preparation is whether the overt act already done are such that if the offender changes his mind and does not proceed further in its progress, the act already done would be completely harmless. तो उसका कितना impact है, जितना act हो चुका है, whether it was harmless or not, that will decide whether it was preparation or attempt. आप इसमें और भी केस लॉज मेंशन कर सकते हो. सिमिलरली इन मदन लाल वर्सेस स्टेट ऑफ राजस्थान 1986, the court while analyzing the stage of attempt held that it is the stage beyond preparation and it precedes the actual commission of the offense. An attempt to commit an offense is not meant to cover only the penultimate act towards the completion of an offense, but it also covers all those acts or series of acts which travel beyond the scope of preparation and exhibit a definite intention and determination to commit a particular offense. तो सिर्फ लास्ट एक्ट ही अटेम्प्ट नहीं होगा, ये जज करना होगा कोर्ट को कि प्रिपरेशन कहाँ पर खत्म हो गया और उसके बाद सीरीज ऑफ एक्ट्स जो भी हुए हैं उनमें से कितने अटेम्प्ट बनाते हैं. It need not be an act which just precedes the last act on the happening of which the offense itself is committed, but it covers all those acts or series of acts which may precede the penultimate act towards the commission of that offense. Then again in Madan Lal versus State of Jammu and Kashmir 1998, it was observed the difference between preparation and an attempt to commit an offense consists chiefly in the greater degree of determination and what is necessary to prove for an offense of an attempt. Then so far we have explained the differences, we have added the case laws. एक छोटा सा paragraph towards the fourth stage भी devote कर देना. I haven't mentioned it here that what is the fourth stage in the commission of offense, and there are various provisions in IPC which deal with the punishment of the fourth stage, that is when the actual act is committed, accomplishment of the actual act. Then let's move to the conclusion. Therefore, the four stages of crime have been defined and adopted by the judiciary for a long time now. The classification of these stages is necessary in order to decide the culpability of a crime at each stage. Generally, the liability arises during an attempt and the actual commission of the crime. The problem before the court that arises more than often is the differentiation between the preparation and the attempt to commit a crime. Various cases have been adjudicated by the courts wherein an attempt has been made to distinguish the thin line between an attempt and preparation of a crime. The courts have been of the view that an attempt shall not be considered only as a penultimate act of the crime. Rather, a series of acts shall constitute an attempt to commit the crime, and the differentiation between preparation and attempt shall depend on the facts, circumstances of the case, and also on the impact of that act on the victim. So in this way you can answer this question. I hope this was helpful to you. I also want to tell you about a free workshop with our expert Mr. Robin Dutt. He is practicing advocate in Punjab and Haryana High Court and Supreme Court of India. He has 25 years of experience. You can join the free workshop to get all your queries related to litigation, judiciary, district attorney, and any other जनरल क्वेरी रिलेटेड टू दी अपॉर्चुनिटीज़ फॉर लॉ प्रोफेशनल्स. कैसे आप एक एडवोकेट बन सकते हैं, अगर आप फर्स्ट जनरेशन एडवोकेट हैं तो क्या क्या डिफ़िकल्टीज़ आप फेस कर रही हैं और उन्हें कैसे ओवरकम कर सकती हैं. अगर आपके ड्राफ्टिंग से रिलेटेड कोई डाउट्स हैं आप वो भी रॉबिन सर से इस वर्कशॉप में पूछ सकते हैं. आपको इस वर्कशॉप का रजिस्ट्रेशन लिंक नीचे डिस्क्रिप्शन में मिल जाएगा. रजिस्टर ऑन दैट. द डेट एंड टाइम ऑफ द वर्कशॉप विल बी टोल्ड टू यू वाया email. So stay tuned. I hope you make the best use of this series. You can also download this PPT from the description below and practice writing down this answer in your notes. इसके अलावा हमारी एक मॉक टेस्ट सीरीज भी चल रही है which is related to MCQs, the prelims questions, for which a video is shared every morning at 11 a.m. So subscribe to our channel. Stay tuned with such important content which will help you a lot in your exams. At iExamB, we help you prepare 50% faster with a crisp and concise content and with our efforts to help you at every stage of your preparation. For any guidance or queries, you can reach out to us on this number. Thank you.